Good afternoon, everyone. Again, I'm Carol Williams with Carol Williams Law Group. My practice is solely immigration and naturalization. Today I'm going to focus in on one area of my practice, which is employment-based immigration. The other area of my practice is family-based immigration, but today I'm going to solely focus on employment-based. And really, what is employment-based immigration? It is helping employers hire and retain foreign nationals, whether that individual is outside of the U.S. or inside the U.S. They can be inside the U.S. working for another company, or they can be potentially going to school, maybe at Georgia Tech and about to graduate, not quite sure what their options are with their different job offers, or they could be in the U.S. and currently unemployed. I help with all of that. Employment-based immigration essentially is split into two sections. There's temporary employment, where someone wants to work for a temporary amount of time and then return to their home country. And temporary could mean 6 or 8 years. So temporary doesn't have to be 1 year, sort of a shorter time limit. And then the second section is permanent authorization. Those individuals that want to, through their employer, obtain a green card and work and live in the U.S. for an indefinite amount of time. So I'm going to start with temporary immigration. Some employment categories under the temporary employment section have a cap on the number of years that you can stay in the U.S. That is certainly one of the things that I look at for every client that I talk to. There are 22 different temporary employment-based categories, 22. So I go through all 22 whenever I'm speaking with someone to find out how many of those 22 they qualify for and what is their best option. And then I talk with my clients about what is their best option. But I always present all of them if they, all of the categories that they actually qualify for. So just to give you sort of the sampling of the 22, I will not go through all of them. Representatives of foreign media have their own visa category. So if you've ever wondered how representatives from the BBC get into the U.S. so quickly and cover stories, it's because they have their own very separate category. International athletes is one category, so you've got a lot of baseball players. You've also got international video gamers qualify as international athletes. Yes, international video gamers. That was really groundbreaking immigration work, not handled by myself, but it is certainly usable by anybody who is a part of that industry. Religious workers have their very own separate category. Intercompany transferees, so if you have, let's say Coca-Cola wants to move someone from their Singapore operations to their U.S. operation, there is a visa type specifically for moving your own employees across the border to make that a little bit quicker for you. Individuals having extraordinary ability. Individuals that are coming in via trade agreements such as NAFTA. If you're thinking about bringing someone in to work for you who lives in Canada or Mexico, there are specific trade agreements and employment-based portions of NAFTA. And folks that are coming in to invest money in the U.S. and whether they're going to be trading money basically back and forth with a specific country of their nationality. Some categories sound pretty self-explanatory, while others are pretty vague. So for instance, extraordinary ability is pretty vague in terms of ordinary speaking, but it has a very set criteria that you must meet in order to be considered extraordinary ability. So I help my clients figure out what the proper category is when they're coming in to work temporarily. The other side of what I do is the permanent side. So let's say someone is hired, they are on a temporary category. I tell them you need to think about what you want to do with this individual long term. You don't treat them any differently, but think about if you want to keep this person on board long term and how does that happen given that they are not a U.S. citizen. So I really do consider myself a partner with my clients and helping them keep their human capital on board and keep their business productive. So on the permanent side, there are 12 different employment-based green card categories. And sort of the sampling of those are folks that work for the U.S. military, individuals that are considered skilled workers. Again, that's really vague, unless you know exactly what the qualifications are. We have exceptional ability and extraordinary ability, which are two very separate categories with their very own separate criteria, but of course they sound the same. So don't be fooled. And then we've got individuals who are doing something that will help the entire country. So those are called national interest waivers. Folks that have gotten national interest waivers in the past have been cancer researchers, because that's not limited to one employer or one area of the US. A cancer researcher can potentially help everyone in the US from coast to coast. So there is that visa category for them as well.